Alright guys, this courtroom wasn't ready for what was coming. A young defendant walks in thinking it's just another hearing. But what unfolds next? Pure chaos. A judge explodes, a mother pleads, and the truth hits harder than any sentence.
They're over your head.
Gotcha.
You see, you're scared now. You're going to be scared later. I'm glad you reacted that way because it is a scary thing. 6 months in jail.
Yeah, I don't want to spend 6 months in jail.
Figure it out. We will go on the record in the matters. 24 TR 718, 24 TR 719, 727, and 922. 23 CF 165, 24 CF 168, 24 CF 240. State of Wisconsin versus Tina Sally. The state appears through District Attorney Kevin Schmidt in person. Ms. Sally appears in person with her counsel, Joseph Rosenthal. We're set today in these matters for pleas and sentencings. Mr. Rosenthal, can you please update the court as to the agreement that has been reached?
Yes, Your Honor, thank you. My client would enter a plea of guilty to an amended count 1 simple possession in 23 CF 165. Counts 2 through 5 would be dismissed and read in. In 24 CF 168, my client would enter a guilty plea to count 2, felony bail jumping. Counts 1 and 3 would be dismissed and read in. 24 CF 240 would be dismissed and read in its entirety. And I believe there is an agreement to dismiss the traffic citations. And both sides would be free to argue. I'm sorry.
What's free to argue? And Mr. Schmidt, I'm going to guess that, and just correct me if I'm wrong, the reason for the public interest for...
The courtroom lights up when the judge stops the defense cold. You issued a subpoena, do says Ticum, but there's no hearing set. Boom. The lawyer tried pulling documents, but the process flawed from the jump. The judge calls it what it is, a discovery request dressed up wrong. Now the attorney's scrambling to explain. The prosecutor annoyed the court, confused. What started as a simple request just turned into a ticking legal time bomb.
For the amendment from possession with intent methamphetamine down to simple possession of methamphetamine is simply because Ms. Sally was at her place of employment and offered someone else the paraphernalia with the methamphetamine in it to take what I would describe as a hit or to use it. And so that's why it's being amended to simple possession.
If the court wants to know the public interest on it, as the court recalls from the PC statement, also in the police report, this was actually referred as simple possession by St. Croix Tribal. DA Renicky charged it as a possession with intent or delivery. He's technically right. That does constitute delivery for the same reason that a bunch of kids passing around a joint in a school circle, like from that 70s show, that would be delivery as well under Wisconsin law. All laws are overly inclusive or underly inclusive. Therefore, it's up to the judgment of people like myself and you, Judge, and Mr. Rosenthal to figure out, when the laws are overly or underly inclusive, what to do there. This is a situation where she just offered someone drugs. They took it for peer pressure reasons. They didn't use it. They reported it to their supervisor. No money exchanged hands. I don't have any information. Tina's, dealing drugs anywheres. So that's the reason why.
All right. Thank you.
And also, Judge, the quantity was like infinitesimally small. I don't even think it was like a 1/10 of a gram. The lab results said like 0.07. So it's just in terms of quantity,
it was very small. The officer wrote in their report it was too small for them to even measure on their scale.
All right. Okay. Thank you. Satisfies the court. Formal motion to amend count 1 and 23.
This isn't just about papers, it's about privacy. The defense wants everything in the probation file. The judge asks, everything, even if it's not relevant. Suddenly, the courtroom's debating where discovery ends and overreach begins. The prosecutor smells trouble. The defense swears it's legit. But when you go fishing with a legal grenade, someone's bound to get hit. The judge must now untangle intent from invasion before someone gets sanctioned for playing dirty.
CF 165 to simple possession and I felony.
So made.
Granted. All right, Miss Sally, that's the agreement that you've reached with the state. Is that true?
Yes, ma'am.
I have in front of me two plea questionnaires, waiver of rights forms. They're identical, except for the charge that you're pleading guilty to and the case numbers. Did your attorney go over, well, and the maximum penalties, they're different too, but as to what those documents state and the form itself, they're identical. Did your attorney go over this form with you thoroughly?
Yes, ma'am.
Did he essentially go over it with you word for word?
Yes, ma'am.
And did you sign both of these documents?
Yes, ma'am.
And do you understand them completely?
Yes, ma'am.
And if you didn't understand something, did you ask him to explain it?
Yes, ma'am.
And he did so?
Yes, ma'am.
So you understand everything in these documents?
I do, ma'am.
All right. Now, you were pleading guilty to 1 count of simple possession of methamphetamine and 1 count of felony bail jumping. You're 49 years old. You have 10 years of schooling. You can read, write, and you understand the English language. Is that all correct?
Yes, ma'am.
You do not have a high school diploma or equivalent. However, like I said, you can understand everything that's going on, right?
Yes, ma'am.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt as to these 2 charges?
Yes, ma'am.
Did your attorney go over with you the maximum possible penalty you're facing?
Yes, ma'am.
You are not receiving treatment for mental illness or disorder, and you've not had any drugs, alcohol, or medications in the last 24 hours. Is that correct?
Yes, ma'am.
Because you're charged with crimes, you are entitled to constitutional rights, and those rights are listed on those documents. Next to the rights is a box, and each of those boxes is checked. That tells me your attorney went over those rights with you. You understand those rights, and you understand that you're giving up those rights by pleading guilty. Is that all true?
Yes, ma'am.
This case isn't about legal motions, it's about second chances. The defense drops the real bomb. My client's done 6 years of probation. That effort deserves weight. Suddenly documents become proof of progress. Missed payments or redeemed mistakes. The judge leans in. The fight is no longer just discovery, it's about whether the system recognizes growth or just punishes the past. Now, the courtroom's not just chasing files, it's deciding a man's future.
Do you need me to go over those rights with you in any more detail?
No, ma'am.
So you understand those rights completely?
Yes, ma'am, I do.
You understand that if you're not a citizen of the United States, your pleas could result in your deportation.
Yes, ma'am.
You understand that you're pleading guilty to felonies. As such, you will no longer be able to use or possess a firearm for life.
Yes, ma'am.
You will no longer be able to vote in any election until your civil rights are restored.
Yes, ma'am.
You understand that the state would have to prove in 24 CF 168, the felony bail jump, that on or around July 14, 2024, in Burnett County, Wisconsin, having been charged with a felony in Polk County case number 22 CF 171, and having been released from custody, you intentionally failed to comply with the terms of your bond by possessing illegal drugs, substances, or paraphernalia, and you did not have any valid prescription to possess any of the items you had. Do you understand what the state would have to prove?
Yes, ma'am.
Do you understand the maximum possible penalty could be up to a $10,000 fine, 6 years of incarceration, or both?
Yes, ma'am.
You understand that in 23 CF 165, count 1, amended to simple possession of methamphetamine, and I, felony, the state would have to prove on or around September 9th, 2023, you possessed a substance. The substance was a controlled substance, methamphetamine, and that you knew or believed that substance was a controlled substance, methamphetamine. Do you understand what the state would have to prove?
Yes, ma'am, I do.
You understand that upon conviction, you face up to $10,000 fine, 3.5 years of incarceration, or both.
Yes, ma'am.
You further understand that there is an agreement here for what's called free to argue. Do you understand that means that each side is free to argue any sentence recommendation to the court that they wish and they desire? Do you understand that?
Yes, ma'am.
Do you understand I'm not bound to follow any of those arguments? I don't have to follow the states. I don't have to listen to the defenses. I must listen, but I don't have to follow. And that I'm free in my own discretion to sentence you to what I believe would be a fair and just sentence for these cases in my discretion only. Do you understand that?
Yes, ma'am.
And that could be the maximum possible penalties Do you understand that?
Yes, ma'am.
Do you still wish to proceed and enter guilty pleas?
Yes, ma'am.
Do you have any questions for the court or your attorney before I proceed?
No, ma'am.
Did you go over the criminal complaints in both of those cases with your attorney?
Yes, ma'am.
In particular, there's sections called the probable cause sections that basically say what happened those days and why you were charged with the crimes. For the most part, are those facts accurate?
Yes, ma'am.
Are you admitting here today that on or around September 9th, 2023, you in fact did possess methamphetamine
Yes, ma'am.
and you knew it was methamphetamine?
Yes, ma'am.
Are you admitting here today that on or around July 14th, 2024, that you knew you were on felony bail with certain conditions and bond in Polk County on a felony case, and that you intentionally violated that bond and those conditions by possessing illegal substances?
Yes, ma'am.
Mr. Rosenthal, may the court use the probable cause sections along with the statements made by your client to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to these two charges?
No, ma'am.
You're doing so freely and intelligently. That means you are telling the court you fully understand what you're doing here today
Yes, ma'am.
and voluntarily.
Yes, ma'am.
Has your attorney represented you competently?
Yes, ma'am.
Has he answered all of your questions?
Tension explodes when they start listing what's missing: jail logs, call history, breathalyzer data. The probation department squirms. We weren't told to hand that over. The defense won't budge. Then why issue a subpoena at all? The court is now knee-deep in bureaucratic red tape, and nobody's on the same page. Evidence is slipping through the cracks, and the judge is losing patience. This isn't just a breakdown, it's a legal system in slow collapse.
Yes, ma'am.
Has he looked at these matters thoroughly?
Yes, ma'am.
Has he discussed with you any potential for legal defenses, or has he said you have no defenses or little defenses in this case?
What? I mean,
The question is whether I've advised you
Oh,
whether there's any
yes, ma'am.
defenses or not.
yes, ma'am.
Talk to you about whether or not you have
Yeah.
any defenses?
Yes, ma'am.
And what, if you go to trial, what could happen?
Yes, ma'am.
Are you satisfied with the services?
Yes, ma'am, I am.
Any questions for the court or your attorney before I proceed?
No, ma'am.
As to 23 CF 165, count 1, simple possession of methamphetamine, and I, felony, how do you wish to plead?
Guilty.
As to 24 CF 168, count 2, felony bail jumping, and H, felony, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find that you understand and that there is a factual basis. I will dismiss and read in all other counts and cases and open matters. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Sure. Checking one thing. Yep. What I would ask the court to do is sentence to Miss Sally to 2 years probation, either withheld sentence or a state and imposed sentence. If it does a state and imposed sentence, I think it should be 9 to 12 months on each concurrent. I don't think the conduct merits prison. Normally I'd say 6 months state and imposed, but I do think the giving of the drugs is worse than just possessing it. For conditions, I think the court should order not to possess drugs with or without a prescription or drug paraphernalia, not to have contact with any known users or dealers except as necessary in a treatment or confinement setting, follow rules of supervision, AOD and follow through, and ability to petition for early discharge once all conditions by probation are complete. I'm just reading this straight off of what she was sentenced to in Polk County. I want to mirror the conditions. In Polk County, the basis of the felony bail jump is she was on a deferred agreement for meth and THC. These cases caused that to be revoked. Our cases are meth and THC, so they're.
The defense crosses the line. He's constitutionally entitled. The lawyer shouts, "Silence." Then the judge fires back, "You're not wrong, but your attitude is..." Mic drop. In that moment, the room freezes. The law might be on the attorney's side, but tone, delivery, and respect just hijacked the discussion. One raised voice nearly cost the client everything. It's a brutal reminder. In court, even when you're right, you can still lose the judge.
Really tightly, heavily linked together. So if the court follows what I'm suggesting, it'll just extend her probation by like 2 months, 2 months longer than just the poke on its own.
Is
But
Polk withheld?
What?
Is Polk withheld?
They did withheld. I just know the court's preferences for state and imposed, which is why I gave the alternative there. I think she reflects a substance abuse issue. The one condition I would add that Polk doesn't is to get a valid license because of the OAR. Her history is substance abuse. That's what she needs help treatment with. She is obviously capable of being a productive member in society. She was working at A&W when this happened. Thank you.
All right. Mr. Rose, go ahead.
I was just gonna say the Polk case is 22 CF 171 if the court's curious about looking at it.
I'm pulling it up right now.
And obviously ours concurrent to Polk. I meant to say that too, sorry.
Yes. All right. Mr. Rosenthal.
Thank you, Your Honor. We would ask for a slightly less term of probation, 18 months. I do think she's a very good candidate for probation. She's made all her meetings with her agent. She was, at the time of the first case, she was working at A&W. After that, she was working at the poorhouse for a number of months. That's kind of on hold right now. She had a bit of a situation with her significant other that she had to get out of. So, and I think to her credit, she made some healthy choices there. She's, now living up in Minong with her brother. She's informed probation of the change of address. She's informed the clerk of the change of address. Again, this was kind of a situation that was, made, I think it was her kind of being proactive and being healthy and getting out of something that was not particularly, in her best interest. Also to her credit, she stayed in very good contact with me throughout the pendency of these cases. Even just a few days ago, she called me, she said, "Hey, look, I don't have a ride down to court." I said, "Hey, Tina, no problem. I'll come and get you on my way from Superior." I'm always willing to go the extra mile for my clients. Again, this is just kind of a reflection on her character of being responsible to both probation and to...
Order is restored but barely. The judge gives a clear ultimatum. You'll get the files properly, through the discovery portal. No games. Everything must go through Mr. Nichols now, or it doesn't happen. The message is crystal. Play by the rules, or get nothing. As the hearing closes, the takeaway is loud and clear: respect the process, or the process will wreck your case. This time, the defense gets the files. Next time, maybe not.